Mr. Rao, Pratham Drishya, from first cursory sight, what are the factors, what are the pointers which go in favor of Brij Bhushan Sharan Singh as of now?
You can see that during trial and the stage of start of trial, that prima facie that is considered by the court whether the allegations are sufficient to proceed in the trial or not. In this case, I think that the contradiction of accused person, the witnesses, and the time gap of the actual allegations, actual incident has been taken place. And these are the things which will be, I think it will be in benefit of Mr. Brij Bhushan Singh. And
Okay.
I don't think that is a case of discharge because prima facie there seems to be a case made out against him and then trial will go on. And as Mr. Vishal has said that in our judicial system, there is a saying that that person, if the allegations are not proved beyond guilty, because the prosecution has to prove their allegations against him, and
Right.
then after that the defense counsel will come out. Then the allegations should be proved beyond guilty, and if there is any slightest doubt, there is our system is judicial system is like that the benefit of that doubt is to be given to the accused always in all cases, on all criminal cases. And in this case
Right.
also I must point out about the bail. The requirement of bail is to face trial in a case, particular case. And in this case, I don't think that there are any chances that he will not face trial in this case. And
Okay.
whatever amount of bail and conditions can be imposed against to Mr. Brij Bhushan Sharan to so that he can continuously face trial and up to the end, he will be obeying all the orders of the honorable court, which are passed during trial.
Right, right, right. Valid point. Valid point. Ashish, let me ask you, a question that generally emanates in everyone's mind. Brij Bhushan Sharan Singh and the co-accused, or for that matter, anyone, those who are accused in a particular charge and are applying for bail, do you think the court also keeps in mind the flight risk, the tendency or the chances of maybe tampering with the evidence or impacting the witnesses? Does that factor also weigh in?
Oh, yes, absolutely. You're absolutely right. These are the factors which are to be kept in mind when granting bail. There are judicial directions from the higher courts, Supreme Court and the high courts, that if there is a slightest possibility that the accused person, if enlarged on bail, maybe, I mean, not it is not like as if he should actually do it, but if there is a likelihood that he may be in the position to tamper with the witnesses, influence the witnesses, the court finds that in such cases, accused should be behind the bar. But as I said, now this is a very politically hyped case. So up to what extent there will be possibility of influencing the witnesses, all these factors will be argued before the court when the court will hear the matter, and then the matter will be decided upon.
Right. Mr. Rao, I think 2013 it was when Delhi had witnessed large-scale protests on the Nirbhaya case. I'm sure, at that time we all had seen how people came out on the streets. 10 years down the line, when we have better facilities of, scrutiny, better facilities of keeping areas and places under surveillance of CCTV, obviously. In this day and age, such a incident happens or has been reported, the way the things transpired, many would say that this situation could have handled better. In your opinion, from the experience that you bring, was this the right way for the government and for Brij Bhushan Singh also to dig in their heels and not heed to the wrestlers' protests? Only Supreme Court intervened, then FIR was filed. Do you believe that this could have been handled better, or this was the best way?
Yes, you are right at this point of time, because after 2013, that Nirbhaya's case, there was some commission was
Yes.
put for the inquiry of that Verma Commission. And after recommendations of that Verma Commission, there were some amendments in our criminal procedure code, and in cases of this type of cases, and that like molestation, POXO, and rape, and other things. then immediate FIR was to be registered on the basis of the complaint received by any person.
Right.
That is a settled law. If there is any complaint, and that case should have been registered immediately, and the investigation should be started. I think Delhi police lacked in that at that stage, that they should have registered this case and investigated, and there should not have been any interference by the Honorable Supreme Court. And that is, I think that the Delhi police is on back footing on this point. But after that, the investigation was conducted on the basis of the available evidence, scientific evidence also, that as you rightly said, that CCTV footage at that time, maybe whether they were or not there, that is part of Chargesheet. And after that, that investigation was fairly done by the Delhi police. I don't think that there was any pressure, and if there was any pressure, I can vouch for the Delhi police that Delhi police never bow down under any pressure, maybe political or any other pressure whatsoever maybe. But in this case, again, that one more point I want to emphasize on that, on the point of bail, that that previous conduct of all, the accused is also influential in the bail, deciding the bail matter, along with the possibility of threatening or all those things. But threatening must be real one. That if there is any simple allegation of threatening, that it will not work out. That should be that threatening allegation should be supported with a solid evidence that he or she has threatened the victim or the witnesses of this case. That is also very important while deciding the case. If there are allegations of threatening, or there are possibilities that he can or she can threaten any witness or to the prosecutrix, then that, and also the conduct and any previous record of criminal cases like this, if there is also there, that in this case also that will be referred by the learned prosecutor, that he has got so many cases against him. Whether he has been convicted or not, that is a separate thing. But these things also are to be considered while granting bail by the learned courts in
itself.
India.
Right, Mr. Rao, I would agree with you, but on one point, the threat and the gravity of the threat. Well, if someone tells me मैं तुम्हारा career खत्म कर दूंगा, and someone tells me that मैं तुम्हें जान से मार दूंगा, for me both are equal. If the career, so I understand what you are saying. I understand what you're saying, that what kind of threat is this? Is it a threat to life or threat to career? For these wrestlers or for any sports person, I would say, the patch that they have, the purple patch that they have, or they tend to stay in the game for a longer period of time, I think they treasure it more than their life. But nonetheless, points taken. Ashish and Mr. Rao, stay with us for just 30 seconds. We'll play this soundbite of the learned lawyer of Brij Bhushan Sharan Singh and the co-accused. Let's listen to what they had to say yesterday.
अभी ये जो बेल है, ये अंतरिम बेल है. बेसिकली इनको अरेस्ट नहीं किया गया था, इस ग्राउंड पर उन्होंने मांगा, उन्होंने कहा कि अंतरिम बेल है और पूरी सुनवाई परसों होगी. कल परसों तक के लिए उन्होंने अंतरिम बेल दी. केस होने के बाद उन्होंने जमानत के बेल एप्लीकेशन उन्होंने मूव करी. बेल एप्लीकेशन की कॉपी हमें सप्लाई करी गई है, और जैसा हमने बेल की सुनवाई के लिए परसों की तारीख तय करी है, और तब तक के लिए उनको इंटरिम बेल दी. आप लोगों ने अपोज किया था? यस, वी हैव अपोज्ड. आज तो उन्होंने बेल लगाई है, क्योंकि उन्होंने कहा कि हम परसों सुनेंगे, इस वजह से उन्होंने अंतरिम जी 25,000 की मुंचल.
Right. So, Ashish, we heard the lawyer and what he the procedures that he mentioned, and now shifting focus to the charge sheet. Two witnesses confirmed seeing the alleged act in Mongolia, offence under IPC section 354 for sexual assault. Singh accused of harassment on 7 separate occasions, 5 instances of physical sexual assault and 1 sexual advance mentions. From the IPC point of view, do they amount to grave scenarios, or they are bailable offences?
No, these are not bailable offences. These are non-bailable offences. And whenever there is allegation from a woman that such instances have happened with her, these are grave offences for all intents and purposes. But here the situation is, because these are old allegations, when one witness says that she or he has seen such particular incident took place before her or him. Now, this may not be legally speaking sufficient to convict that person on the basis of this particular statement.
Okay.
There must be other witnesses. I mean, let's for example, There are two people in this particular room, and one says that that person has seen that particular offense being committed, and other says, I cannot recall this particular incident ever took place.
Right.
Now, for legal point of view, you see there is a doubt which has been created under the law. Now, and law says if there is a slightest doubt, the person cannot be convicted. These are, parameters on which our legal system works. So that's why I'm saying it's a weak case from the very beginning. And you see, one of the reason why this case has reached this stage is because when police is not listening to you, suppose there is a cognizable offense which has happened, and I go to a police station and ask the concerned police officer to get the FIR registered, and if he refuses for whatever reasons, there are other recourses which are available under CRPC, and that could have been used in a very timely manner. That might have made this case a legally solid case for up to a certain extent. But because this political angle somehow, I would like to say now this case has become a khichdi case. We don't know how this will. Yes.
Right. Rao Saab, Ashish has been very candid and obviously putting, because why I'm saying candid, Ashish and Rao Saab, because the impression that, some people would say that media creates that impression. But when we also walk in the street, the general perception here is that because of some sort of political upper hand, there is some sort of delay in the case. But again, judiciary, full faith in them, and now the case is in the courts. Talking about the gravity of the charges and the charge sheet, details, Rao Saab, allegations of 7 instances of harassment by Singh, including 5 physical sexual assault and 1 sexual advance. All these things I just read out. Do you believe that for the accused, it also becomes difficult to prove that the charges are not true? Because for him also, not only for the police, but for him also, a lot of time has passed.
Definitely, this is the most important aspect of this case, that if the sexual allegations, sexual harassment allegations or molestations of that time are being quoted right now, then there must be some plausible explanation of delay in reporting this matter, because this is also very important why the matter was not reported at the same time, at the same place when these offences has been committed. So this will also be counted or it will be considered during trial. And this will be a benefit for the accused in this case. Now, the main our process of our judicial system in criminal trial is that first the prosecution has to prove their case. Like in this case, that public prosecutor was speaking, not that the lawyer of this Brij Bhushan was speaking. Mr. Atul Srivastava is a public prosecutor. He was the person from the police. He was speaking that in that case about the bail he was talking about. Then in that case, if that case is being tried in the court, then the prosecutor has to establish their case on its own leg. That the case should be proved beyond any reasonable doubt. And after that, when the witnesses are examined in chief, then the cross-examination is a right of the accused, that he can cross-examine on the issues which have been narrated before the honorable court during trial of any such type of cases. So it will be, I think, in the benefit of this delay in reporting the matter definitely will be in favor of the accused. And about the gravity also, I must tell you that the gravity offense, that passing advance marks is a bailable offense. And molestation, and that is, if it is covered under section 354, this is non-bailable offense. And that's why, because the non-bailable offense is there, that's why the bail, regular bail has been applied for by the accused. So now it is to be decided by the honorable court, and after the bail matter is decided, then the court will proceed as per law for the further trial of this case. And then after that, argument of charge and the prosecution evidence, that will be followed by after argument of charge, if it is the charges are framed against him.
Ashish, I'm sure that unfortunately enough, though, this is not the first instance or a first type of a case where a person has been accused of sexual misconduct. There have been cases before also, and not so much into the media glare, not involving high profile people, at least in the recent past. in your opinion, how do courts view it? Because there is a feeling that this particular case is being treated differently than other cases of sexual misconduct. Is that so, or maybe in a way for the courts to take every step into consideration is a must, and hence the delay?
You're right. I mean, you see what happens that we may have some sort of perception that courts can do whatever they want, but as far as trial courts are concerned, they are bound by law. Like they have superior courts above them. Every step is being watched by superior courts. Like if they do anything which is not in accordance with law, I mean, the first thing lawyers for concerned persons before the court, they will approach higher court, or there may be certain remarks which may not be very good for the lower court. So lower
Right.
courts are very hesitant as far as the social justice thing is concerned. They strictly adhere to what letters of law are saying. So whatever is being presented, see, court is a neutral body. They are not pro prosecution or pro victim. It is for the prosecution to build a case before the court so that they can pass a judgment, and equal rights are available to the accused persons to defend themselves. That's how things play out in court. So if the prosecution is not fulfilling its part, then court's hands are bound. They cannot do anything beyond a certain point.
Right. And when it comes to, Mr. Rao, handling situations like these or tackling, these high-profile cases, what recourse and what plan of action does Delhi police follow, or police generally follow, so that they are also not being accused of, shielding a particular person who is very close to the government or who is a minister, for that matter? So, what kind of approach is there as far as Delhi police is concerned?
This is very, very relevant and very good question about in this case, because Delhi police has made it a point that in such type of cases, which is a very high profile case and which involves a main accused person as a minister, rather is a parliamentarian, then the police has to do everything on merit. So just to also not only doing things on merit, that is to look like that the police is investigating that case on merit without any pressure and from any corner. This is the main principle by the investigating officer, that in such type of cases there should not be any allegations against them that they are partial, impartial, and they are doing something which is not required or which is not legally required by the investigating officer to be done. They have to go by the rule of law, rule book, and what is the procedure of the investigation, what are the latest judgments, what are the latest rulings in our judicial system. They have to abide by all these things so that there should not be any allegations against them. And I think in this case also, the police tried to do very fair in the investigation. No doubt there are allegations. There were allegations that why the police did not arrest the Brij Bhushan Singh, or why the police delayed in registration of FIR. That is there definitely. The delay in registration of FIR, definitely one of the point is that I am emphasizing time and again that should not have been done. But after that, the investigation was done by the officers of a very high quality, and then the special investigation team of crime branch investigated this case, and the investigators were of very experienced, and they did their job meticulously, collecting the all type of evidence, that you can say the oral evidence, scientific evidence, documentary evidence. So many other evidences are being placed before the court during the charge filing in the charge sheet filed by the court by the police in the court. So now I think that analysis of this whole charge sheet will definitely come out that whether there is any sufficient ground to proceed against the accused, and if there is sufficient ground to proceed in the trial in the accused, and the trial will show that whether the allegations are correct or not. Definitely, I think that's a wait and watch situation for all of us.
Right, Mr. Rao. I'll be taking one final question from both of you. But yes, as far as Delhi police is concerned, I mean, not many would say that this police force is an inefficient one. Delhi police has set many high standards, I would say. But Ashish, let me ask you a completely opposite question here. The popular belief here is, because Delhi police falls under MHA, because Brij Bhushan Singh is a minister and an MP. Do you think that Brij Bhushan Sharan Singh is being shielded?
I'm sorry, your voice was breaking.
Yeah,
I couldn't hear the
I
last
was
part.
asking, the popular perception here is, and I just wanted your opinion on it, legally or personal. Do you think Brij Bhushan Sharan Singh is being shielded?
You see, first, let me tell you, Delhi Police is a very competent and
Right.
efficient agency. Like, we have so many friends in Delhi Police, and we know how they work day and night.
By all
But
means, I would agree.
yeah, yeah, yeah. And but as far as this particular case is concerned, you see, personally, I feel that there was initially there was some hesitation to register the FIR. Post registration of FIR, even they could have taken the stand that we have registered the FIR, and during investigation we could not found anything which was incriminating. But what has happened? Now we are seeing that Delhi Police has filed the charge sheet where
Yeah, absolutely.
charges are pressed against this person. So the initial stand
And
that
big ones.
nothing was there, yeah, nothing was there against this accused person. So there is a contradiction, and I don't know how this contradiction can be reconciled. I mean, viewers are free to choose whatever way they want to
Right.
perceive things. Yes.
Right, Ashish. I was expecting, a balanced view from you, and yes, I mean that's why trusted legal luminary Ashish Pandey there. Rao Saab, one obvious question would have been to reply to Ashish what he said, that what Delhi police could say. But my question would be to you, would be the final question, and after that we are all free to go. Uh, Only a few days ago, sir, there was an incident. A reporter from a particular television station, media network, was approaching Brij Bhushan Sharan Singh, and he was heading to his car. Maybe he had a rough day, maybe he had a long day. He shut the car door on the reporter's microphone. Now, obviously, as the social media would have it, it was not seen in the correct light. What was the exact moment, heat of the moment, or what was there? But if that situation was avoidable at all, it could have been. In your opinion, sir, both what you bring to the table from the police department and your legal opinion, what message or what suggestions would you give to Brij Bhushan Sharan Singh as of now, who is out on bail or on interim bail, to exercise at this point of time?
Definitely, the Brij Bhushan Singh is not a normal person. He is a parliamentarian. He is a minister of the ruling government. His behavior should be like that. That should be that should not annoy anyone, and particularly not to the media person. That he should have a balanced state of mind at that very point. Maybe he may be frustrated, maybe because of something. I don't know what was the situation at that time. But as a normal person, also as a parliamentarian, because the people watch his activities, people not only
Valid
his
point, sir.
activities.
Valid point.
We Indian watch our these parliamentarians, what they are saying, what they are doing. That's why the people should feel that he is also a nice person. Because but by banging this door of that mic of that media person, that I don't like it at all, and that should have been avoided by him. And he should restrain all these things in future as well. As you asked me that what
What
type of
message?
suggestion you want to give to. Yes.